So, very good evening, friends. Today, we will start with pre-pack insolvency resolution process. So, we'll initially start with the code, whatever is given in the code and regulations, and then we'll move on to the case studies. So, first of all, who is eligible? An application for initiating pre-packaged insolvency resolution process may be made in respect of a corporate debtor classified as MSME. So, only MSME is eligible as per section 54A subsection 1. Another question is whether Udyam registration is necessary. It is not necessary. It says that it should be classified as a micro, small or medium enterprises. And who is classified as micro, small and medium enterprises, that you all know, depending upon the turnover criteria. So let me start. Let me open that PPT also side by side. So let me start with this PPT also. So I'm side by side opening two PPTs. One is this regarding this section wise coverage, and another is on this bare code. Because in bare code, you have to again and again refer to the regulations. Just a minute. Screen sharing. Multiple sharing. Okay. So section 54A, subsection 1 says that this is applicable only to MSMEs. An application for initiating, just let me read from the bare code. An application, I'm reading from the bare code now. An application for initiating prepackaged insolvency resolution process may be made in respect of a corporate debtor classified as a micro, small or medium enterprises. So first of all, we have to see the definition of micro, small and medium enterprises. Please explain the basic reason. Okay, Vaibhav Gupta ji is asking, what is the basic reason for bringing in PPIRP? Actually, the basic reason for bringing in PPIRP has been given while initiating this, while introducing this chapter 3A. Basically, they wanted to protect and promote MSMEs, micro, small and medium enterprises. And they wanted to bring a simplified process for MSMEs. They wanted that the control should be retained with the corporate debtor itself, because in CIRP, as we know, the control shifts from the board of directors to the insolvency professional. But here, the corporate debtor stays in control. He is the one who is initiating this application, and only MSMEs can initiate this application. Minimum default amount is also less. So the basic purpose, as it has been explained while introducing this chapter 3A, is that they wanted to protect micro, small and medium enterprises because they generate a lot of employment and they help in economic growth and all. So that was the basic idea behind introducing. So it says 54A says that an application for initiating may be made in respect of a corporate debtor classified as MSME. Now, what is this MSME? Just a minute. Screen sharing, stop share. And let me again share that screen. This is the MSME as per the criteria which is applicable to us. Because as we know, the cutoff date for our syllabus is 28th of February 2022. So this is the criteria. Investment, it does not exceed 1 crore. Turnover does not exceed 5 crores. In case of small investment does not exceed 10 crores and turnover does not exceed 50 crores, and minimum investment does not exceed 50 crores and turnover does not exceed 250 crores. So this is the criteria. And in case there is an upward change, then so we have to see as per this criteria. This PPT is already available on my YouTube channel. So you can see the detailed deliberation on MSME also. There is a separate PPT on MSME alone. There is a separate video lecture on MSME alone. So what we have to do, we have to see the criteria whether the corporate debtor who is initiating this pre-pack comes under this MSME or not. So in case turnover exceeds 250 crores or investment exceeds 50 crores, then you are out of this. So maximum investment should be 50 or less, 50 crore less, and turnover should be 250 crore less. Export turnover is excluded. Normally, the investment is also the WDV as per the ITR filed by the company. And for one PAN number, it is one investment and one turnover. This is in brief regarding this. Regarding detail, I've already given in my section-wise coverage. Okay, you can go through this, that a composite criteria of investment and turnover shall apply. So both the criteria should be satisfied, investment as well as turnover. Suppose the investment in your company is up to 50 crores, okay, but turnover exceeds 250 crores, then you are out of this MSME clause. Now, let me again share that screen. So 54A. 54A what says? An application for initiating pre-pack may be made in respect of a corporate debtor classified as a MSME. MSME definition you have already seen. Now without, yes, William Rajuji, please. चट्टोपाध्याय जी अनम्यूट कर दीजिए इनको.
Sir.
Yes, sir. Please.
It is R or and?
And it is a composite criteria. And so both the things should be satisfied. That is why I've amply clarified it, abundantly clarified in my section-wise coverage, PPT on slide number 257, that it is a 258 composite criteria. A composite criteria of investment and turnover is. So
in the act, sir, it is there in the act?
Actually, it is as per the notification. Different notifications are there on different dates. So this is the notification as on 26th of June 2020.
No, when I'm reading it, the MSME, they said it is R.
No, I can make you co-host and you can share. So you are reading it from hard copy?
No, I had read MSME somewhere, hard copy.
Okay, no issues. You can post it in the group. You can post it in the group. We can, but
the question is R or and? That is
it is and. It is and. There is a composite criteria. So composite criteria. Composite criteria means both. Yes. So now again to this. Without prejudice in subsection 1, an application for initiating PPIRP may be made in respect of a corporate debtor who commits a default referred to in section 4. As we know, section 4 talks of default. But normal default in case of CIRP is 1 crore. Here, the default is 10 lakhs. But it has not undergone pre-pack insolvency resolution process or completed CIRP during the period of 3 years. It is not undergoing CIRP. No order requiring it to be liquidated is there, and it is eligible to submit a resolution plan. So these are the criteria in addition to what is referred to in section 4. And section 4 talks of 2 criteria, one for normal companies and another for MSMEs. For MSMEs, the default amount is 10 lakhs. the financial creditors of the corporate debtor not being its related parties representing such number and in such manner as may be specified have proposed the name of the insolvency professional. So these are the various criteria. As we know, if we read Bear Code, section 11 talks of also certain ineligibilities, certain class of companies are ineligible. Suppose some they are already undergoing some CIRP or 12 months have not elapsed. So similarly, for this PPIRP also, in case it is already undergoing CIRP, because this CIRP came somewhere in 2020. And prior to that, the companies were coming under CIRP only. So if some companies already undergoing CIRP or a liquidation order has been passed or it is ineligible to submit a resolution plan. And so in this case, in such a scenario, such a company, such a corporate debtor cannot apply, cannot initiate this pre-packaged insolvency resolution process. So these are some of the disqualifications that such class of companies cannot initiate pre-packaged insolvency resolution process. Then this E. E says the financial creditors of the corporate debtor not being its related parties representing such a number and in such manner as may be specified. So what is specified? It is given in the regulations. So if we go to the regulations, they specify that, okay, financial regulation number 14, regulation 4. The financial creditors who are not related parties of the corporate debtor and have not less than 10% of the value of the total financial debt of such creditor may propose names of insolvency professionals for the purpose of clause E of subsection 2 of section 54A. So, who are eligible to propose the name? Unrelated financial creditors who have not less than 10% of the value of the total financial debt. So first of all, total financial debt will be ascertained. And in case of CIRP, as you know, it is based on the amount claimed and amount admitted. The voting criteria is based on that. But here, the list of creditors is given by the corporate debtor itself. So from where this calculation of 10% will be taken, this calculation of 10% will be taken as per the list provided by the corporate. So they will propose the name. Anybody cannot propose. Here, who represent not less than 10% of the value. So there will be out of list, we will separate first of all unrelated parties and then unrelated parties who have not less than 10% of the debt. So only those persons, only those unrelated financial creditors who constitute not less than 10% of the total debt, they can propose the name. They can propose the name. And then up to then 66% out of them, if they vote for approval of a particular name. So suppose there are 4 financial creditors, suppose there are 4 unrelated financial creditors who constitute 10% or more of the debt. Out of they all propose different names. Then out of those 4 names, voting will take place, and the one who gets not less than 66% of the votes will be selected as a resolution professional. So this is the essence of this point. Section 54A to E. Provided that where a corporate debtor does not have any financial creditor, not being its related party, suppose there is no financial creditor, or either all the financial creditors are related parties. So in this case, it will be done as per the OCs. So 10 largest operational creditors, they will vote in such a scenario. The majority of the directors or partners of the corporate debtor, as the case may be, have made a declaration. So now they are in 54A, they are talking of various conditions that who is eligible. First of all, you have to see that it is an MSME, number 1. Number 2, default is there. For default, you see section 4. Then you have to see whether it is already undergoing some process. So that also is not able to initiate this pre-pack. Now this selection of RP by not less than 10% of the unrelated financial creditors, and they will do voting. They will propose the name, and the one which gets not less than 66% in value, he will be selected. And in case there are no FCs or all the FCs are related parties, then this will be done by the OCs. Next point. Now they have selected the resolution professional. Majority of the directors or partners of the corporate debtor, as the case may be, have made a declaration. As we know, as per section 59 also, in case of voluntary liquidation, also similar declaration is to be made by the majority of directors or partners. So here also majority of the directors or partners, but the word is majority. So majority means simple majority. Majority of the directors or partners, as the case may be, have made a declaration in such form as may be specified, stating inter alia what? That the corporate debtor shall file an application. So here they are expressing an intention to file an application within a definite time period not exceeding 90 days. Then this prepackaged insolvency resolution process is not being initiated to defraud any person. So you can correlate this section with section 59, which talks of voluntary liquidation. And the name of the insolvency professional proposed and approved to be appointed as a resolution professional under clause E. Okay. So here what they do, they select a resolution professional based on voting, and then they pass a resolution. Majority of the directors or partners, they make a declaration. Declaration is also in a specified form. And then the members of the corporate debtor have passed a special resolution, or at least 3/4 of the total number of partners, because it might be either a company or an LLP. So in case of LLP, at least 3/4 of the total number of partners, not only designated partner, but all the partners. And if it is a company, then they will pass a special resolution. Special resolution also means 75% or more. Of the corporate debtor, they have passed a special resolution approving the filing. Vaibhav Gupta ji, please.
Sir, why will the corporate debtor, approve this PPAC insolvency by ISR? जब creditors उनको move कर रहे हैं, तो it will be in many situations prejudicial to the interest of the partners or the directors of the corporate debtor.
No. Basically, in case of pre-pack, creditors cannot move an application. Basically, nobody can move an application except the corporate debtor. Corporate debtor itself can only move the application.
But RP appoint करते हैं financial creditors.
RP, yes, because as per section 7 also, suppose suppose it is a normal CIRP. Had it been normal CIRP, then as per section 7, financial creditors would have filed an application, and they were entitled to appoint an RP there also. So similar is the situation here.
But over here, CD moves an application and FCs appoint RP.
Yes. Because in that case also, after COC is constituted, they can replace the IRP with another RP. So similar is the situation here. So here they are trying to shorten the timelines also. So they are trying to quicken the process. And this way, by 66% majority, they have already obtained the approval of the majority of the unrelated financial creditors, which is similar to CIRP process. But the application in case of PPIRP can be moved only by the corporate debtor and not by the creditor. So what they have done is they have combined the advantages of various processes. Like they have taken some of the features of voluntary liquidation. They have taken most of the features of CIRP and things like that. Participants.
Exit mechanism दे दिया basically.
हाँ. किन का वो आप अनम्यूट कर दीजिए चट्टोपाध्याय जी.
Sir.
हाँ जी. William Raju ji, yes please.
Sir, you said only corporate debtor can initiate PPIRP application.
Yes.
In case of how suppose generally they don't like to move it. It is only creditor interest is protected.
No.
Then
no, actually what happens is here the advantage, as you know, before this IBC, companies were going for one-time settlement also. So this is something similar to one-time settlement, but it has the additional advantage of approval of the adjudicating authority also. Here, basically, what they are offering, the CD, what CD is offering, he is offering a haircut to the financial creditors. He is not able to pay the full amount. So he will ask them, okay, I can pay 60% only. If they agree and it gets the approval of the court also, so it is an advantage over the one-time settlement also. And bankers also may agree because they know that even if they initiate CIRP, they are not going to get the full amount because there is hardly any money left in the company. So they
The
may
question
agree.
is, sir, if we won't apply for a PPIRP,
Yes.
then what is the solution? He won't pay, but he won't apply for PPIRP.
Okay. So in such a situation, because the minimum default amount for normal CIRP is 1 crore. Here, the default suppose is less than 1 crore. Anna? If it is 1 crore more, they will go for CIRP normal provisions. The banker will go. Anna?
No,
But-
even suppose, sir, if it is defined as an MSME, see, they cannot go under CIRP, no?
Why not? They can go. Why not? They can always go, provided the minimum default is 1 crore. Even this PPIRP, if it fails, it can be converted into CIRP. It's not that they cannot go in for
Achha.
CIRP. Basically, it is a lower threshold to initiate this process for MSME.
Achha. Okay.
Now, suppose the default is 1 crore more. This is the minimum amount of default. No, this is not the maximum amount.
Yeah.
In case of MSME also, the default could be more than 1 crore. So they will go for normal CIRP. But even if the default is more than 1 crore, they can go in for this PPIRP. That is the advantage. So it is something similar to one-time settlement, and bankers may also agree to it, depending upon the condition of the client. What is the advantage to the corporate debtor? The advantage to the corporate debtor is that it gets the seal of approval of the adjudicating authority.
So, as long as the default is less than 1 crore, the corporate creditor cannot move application.
They can go to civil court, they can resort to other remedies. Suppose they have got the property mortgage, they can take a action under SURFACE, they can go to DRT and things like that. If they don't have property, they can move to civil court. So other remedies are available, but not this IBC.
Okay.
So members of the corporate debtor, they have passed a special resolution, or at least 3/4 of the total number of partners, they have passed a resolution approving the filing of the application. So RP name is approved. There is a declaration by majority of the directors or partners, and members have also moved a special resolution. Now, 54A3, the corporate debtor shall obtain an approval from its financial creditors, not being its related parties, representing not less than 66% in value of the financial debt due to such creditors, for the filing of an application for initiating prepackaged insolvency resolution process in such form as may be specified. So the unrelated financial creditors, what they are doing, they are giving two approvals. They are giving approval for the name of the financial creditor, for the name of the RP, based on the voting, 66% voting. Not unrelated financial creditor representing not less than 10%, they can propose the name, and based on the voting of not less than 66%, they can select an RP. Another approval which the financial creditors are giving is that they are approving the filing of application. So this filing of application also has to be approved by the financial creditor, unrelated financial creditors. Without their approval, this application cannot be moved.
Show of hands है सर देवरूपा दे मित्र.
है?
Show of hands है सर देवरूपा दे मित्र. अब देख लीजिए.
हाँ. Provided that where a corporate debtor does not have any financial creditors, not being its related parties, the approval under shall be provided by such persons. So OCs, if not FCs, then OCs. Next, prior to seeking approval from financial creditors under subsection 3. So prior to this approval from financial creditor for initiating this application, the corporate debtor shall provide such financial creditor with declaration. So declaration will precede the approval by unrelated FCs for filing the application. So For FCs, they will ask for declaration. Okay. But you have come to us that we approve your application, that we approve your filing of application for initiating PPIRP. But whether you have consulted in the company, whether most of the directors agree to this proposal, whether most of the members agree to this proposal. So they will forward this declaration to the financial creditors. Special resolution, a base resolution plan, which conforms to the requirements. So this corporate debtor will be provided, this financial creditor will be provided with these things: declaration, special resolution, and a base resolution plan, which conforms to the requirement. Because as a banker, we know that bankers also need to obtain approval from their legal department or from their head office or regional office, from the higher ups. So they must have this information that, okay, we are agreeing for initiating of this PPIRP, but what is the plan? What is the offer they are giving? So it is something similar to one-time settlement. So declaration, special resolution, and a base resolution plan. Next. And such other information and documents as may be specified. Now, duties of IP before initiation of prepackaged insolvency resolution process. Now, this prepackaged insolvency resolution process has not yet been initiated, because it will be initiated once the application is admitted by the adjudicating authority. But here some activity is going on. So what is the role of an insolvency professional during this phase before initiation of prepackaged insolvency resolution process? The insolvency professional proposed to be appointed as the resolution professional shall have the following duties commencing from the date of the approval under clause E of subsection 2 of section 54A. So once this approval is given as per clause E, and clause E, what it says? The financial creditors not representing 66%. So once they approve, they have approved the name, but the process has not yet been initiated. Then what the IP will do? IP will prepare a report in such form as may be specified, confirming whether the corporate debtor meets the requirement of section 54A. So we will see whether it is an MSME, whether it is not already undergoing CIRP, whether some PPIRP has not already taken place. So all those requirements which are given in 54A, this insolvency professional will see. You can correlate this with individual insolvency, where the resolution professional has to submit a report to the adjudicating authority whether this application should be admitted or not. So this is something similar to it. So he will prepare a report. And the base resolution plan conforms to the requirements referred to in clause C of subsection 4 of section 54A. So he will confirm these two things: whether the corporate debtor is MSME and some process is not, it is not already undergoing CIRP, no order of liquidation has been passed, it is eligible to submit a resolution plan under 29A. Because basically here there is no resolution applicant, only the base resolution plan is there. And this base resolution plan has been prepared by the corporate debtor only. Because if we go to section 5, section 5 talks of the definition of base resolution plan. Section 5, subsection 2A, it talks of the definition of base resolution plan. So base resolution plan means a resolution plan provided by the corporate debtor under clause C of subsection 4 of section 54A. And will file such reports and other documents with the board as may be specified. So we will file certain documents with the IBBI also and perform such other duties as may be specified. And the duties, so these are the basic duties. So basically he is confirming that initially, because the adjudicating authority may not have so much time to look after all the things. So this duty is entrusted on the resolution professional, that okay, you satisfy that it is an MSME, it is not undergoing CIRP and all those things, and base resolution plan which has been put forth by the corporate debtor, it also meets the requirements. Duties of insolvency professional under subsection 1 shall cease if the corporate debtor fails to file an application. Now there could be a situation where this resolution professional was selected. But in the report, he found that the corporate debtor is not falling under MSME. So they may not file the application. The corporate debtor fails to file an application for initiating because within a specified time period, not exceeding 90 days, they have to file the application. But suppose they don't file the application, or the application is admitted or rejected by the adjudicating authority. So in both these situations, the duty of the insolvency professional will cease. Either it will be admitted or rejected, or it will not be filed at all. So in all these three situations, the duty of the insolvency professional will cease. So this is the first role of insolvency professional. Now, the fees payable to the insolvency professional in relation to the duties performed under subsection 1 shall be determined and borne in such manner as may be specified, and such fees shall form part of pre-packaged insolvency resolution process cost if the application is admitted. Now there could be three scenarios. Suppose this application is rejected, then in this case, the fees payable to the insolvency resolution professional will be borne by the corporate debtor. Or in case this application is at all is not filed, then also the fees will be borne by the corporate debtor. But if this application is admitted and this pre-pack insolvency resolution process commences, then in that case, it will form part of the pre-packaged insolvency resolution process cost, like CIRP cost. Now, 54C. 54C says that application to initiate pre-packaged insolvency resolution process. So where a corporate debtor meets, now the report has been given by the insolvency professional that okay, he meets the requirements, and a corporate applicant thereof may file an application with the adjudicating authority for initiating pre-packaged insolvency resolution process. The application shall be filed, so there is a form, etc. Along with the application, what are the documents to be furnished? Declaration, special resolution or resolution, and the approval of the financial creditors for initiating pre-packaged insolvency resolution process. So all these documents which were given to the financial creditor also, because all these documents were given to the financial creditor also before admitting the application. This 54A4 says, prior to seeking approval from financial creditors, the corporate debtor shall provide such financial creditor with this declaration, special resolution, and base resolution plan. So financial creditors were already furnished these documents. Now these documents are being again furnished to the adjudicating authority. The name and written consent in such form of the IP and a declaration regarding the existence of that may be within the scope of the provision in respect of avoidance of transactions. So we have already seen the provisions regarding this preferential, undervalued, extortionate. So if there are any transactions, a declaration also has to be given whether there exists any transaction, and this declaration has to be given by the corporate debtor itself. So this is another feature which is different from normal CIRP, because in normal CIRP, it is the duty of the RP or liquidator to find out these PUFE transactions. Here, the declaration is given by the corporate debtor itself. And next is the information relating to books of accounts of the corporate debtor and such other documents. Adjudicating authority has got a period of 14 days. So within the period of 14 days or some additional period which they may require, they may admit or reject the application. And if they before rejecting the application, opportunity of being heard will be provided. If there is any defect in the application, so they will give notice to rectify the defect within 7 days. So these are the normal provisions as per normal CIRP. And this pre-packaged insolvency resolution process, it will commence from the date of admission of the application. So up to here, I think things are clear. Now 54D, time limit. This time limit is a bit lesser than the normal CIRP. Normal CIRP is for 180 days. Here it is for a period of 120 days. The pre-packaged insolvency resolution process shall be completed within a period of 120 days from the prepackaged insolvency commencement date. चट्टोपाध्याय जी देख लीजिएगा, कोई चैट वगैरह में भी कोई इंपॉर्टेंट हो तो बता दीजिएगा. हाँ, KU रायडू जी ने बोला है, it is hand. I think he is referring to MSME composite criteria. Okay. Without prejudice to subsection 1, the resolution professional shall submit the resolution plan as approved by the committee of creditors to the adjudicating authority under subsection 4 or subsection 12, as the case may be, of section 54K within a period of 90 days. So, total time period for completion is 120 days. For approval of plan, 90 days period is there, and 30 days is left for the adjudicating authority. And where no resolution plan is approved by the committee of creditors within the time period referred to in subsection 2, the resolution professional shall, on the day after the expiry of such time period, file an application with the adjudicating authority for termination. So, either resolution or termination. Another point which arises here is whether any extension of time period is there. There is no provision for extension, but they may apply for exclusion of certain period in case certain time period is lost in some litigation, etc. That is up to the adjudicating authority to exclude certain period. Now 54E. 54E says, yes, declaration of moratorium and public announcement. The adjudicating authority shall, on the prepackaged along with the order of admission, it will declare a moratorium. So this is, in this case, reference is given to section 14 here also, that the provisions will apply mutatis mutandis to this. Then they will appoint a resolution professional as named in the application if no disciplinary proceeding is pending against him. So first of all, an RP was selected by the unrelated financial parties who constituted not less than 10% of the rate. Here, the adjudicating authority is appointing the resolution professional because the duties of the earlier resolution professional already ceased. But in the application, they are giving the name. In the application, which is giving, they are giving the name and written consent of the insolvency professional. But the appointment is done by the adjudicating authority. If no disciplinary proceeding are pending, if some disciplinary proceeding are pending, they will make a reference to the board. A board is already sharing a panel with the adjudicating authority, and they will appoint one resolution professional out of that. And based on the recommendation by the board, so they will appoint. Cause a public announcement of the initiation of prepackaged insolvency resolution process to be made by the resolution professional in such form and manner. This public announcement here is different from the public announcement in case of CIRP, because in this case there is no publication in the newspaper. The order of moratorium shall have effect from the date of such order till the date on which the prepackaged insolvency resolution process period comes to an end. So this moratorium will cease to have effect after the period of 120 days. Now, duties and powers of the resolution professional during this prepackaged insolvency resolution process. So we have already seen one set of duties which were before the initiation of PPIRP. Now we are seeing the duties and powers of RP during PPIRP. Yes, Vaibhav Gupta ji, please. पूछिए.
सर मॉरिटोरियम देने का ऑब्जेक्टिव क्या रहता है?
भाई देखिए, ऐसा है, कोई भी प्रोसेस मॉरिटोरियम का ऑब्जेक्टिव ये है ना कि भाई देखो, ऐसा है कि कोई और डिस्टर्बेंस नहीं होगी. भाई ऐसा नहीं ना कोई दूसरा एप्लीकेशन फाइल कर दे, अदरवाइज क्या होगा, इस सब में टाइम, लिटिगेशन में टाइम वेस्ट हो जाएगा. फिर 120 दिन में प्रोसेस कैसे कंप्लीट होगा? इट विल नॉट बी एबल टू कंप्लीट दिस प्रोसेस ना, बिकॉज इट इज अ टाइम बाउंड मैकेनिज्म. सो दे डोंट वांट एनी डिस्टर्बेंस. सपोज ए पेशेंट इज लाइंग इन ए हॉस्पिटल, इफ यू कंटिन्यूअसली डिस्टर्ब हिम, हाउ डॉक्टर्स विल ट्रीट हिम? So similar is the provision here, no litigation. If there is any criminal litigation, then okay, let it go on. But for civil proceeding, they will be put on hold. And anyway, no harm is being done to their interest also, because as soon as this moratorium is lifted, they can again resume the proceedings. And this period will be excluded for this limitation period also. So similar is the logic as in case of section 14, that okay, let it go undisturbed. I hope I'm clear. हाँ जी वैभव जी. Now duties and powers of the resolution professional during pre-packaged insolvency resolution process. The resolution professional shall conduct the pre-packaged and he will perform the following duties. First of all, this preparation of the list of creditors is the responsibility of the CD. And what he is doing, he is confirming the list of claims submitted by the corporate debtor. How he will confirm? He will write individually to each and every creditor, because it says as may be specified. So regulations talk of this 54F. So in regulations, this process is given 54F. Let me go. List of claims. Regulation number 20 talks of this. The corporate debtor shall submit a list of claims under subsection 1 of section 54G in form P10 to the resolution professional, and based on the records of the CD and the RP will confirm the details received in form P10. The resolution professional shall inform every creditor regarding its claims as confirmed by him and seek objections if any. And this form 10 is available for inspection by the creditors, members, partners, displayed on the website if any of the corporate debtor, filed with the board on electronic platform, and presented at the meetings of the committee as and when updated. So primarily the duty is of the CD to prepare the list of creditors, and he is confirming the list by individually communicating with each of them. He will inform creditors regarding their claims as confirmed under clause A in such manner as may be specified. The regulation talks of this. The regulation talks of regulation number 20 regarding list of claims, 21 regarding determination of amounts of claim, 22 regarding debts in foreign currency. So similar to CIRP provisions. Maintain an updated list of claims. So some claims may come at a later date, so we will update them. And this form P10 will be updated from time to time. He will monitor management of the affairs of the corporate debtor, and he will inform the COC in the event of breach of any of the obligations of the board of directors or partners, because here the board of directors or partners, they stay in control. So if there is any breach of any obligations, so they will inform the COC. He will constitute. Yes, Vaibhav ji, please. पूछे वैभव गुप्ता जी.
So the role of
हाँ.
RP यहाँ पे काफी लिमिटेड रहता है in terms of management of the CD, क्योंकि board of directors तो रहते ही हैं.
हाँ बिल्कुल 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 ठीक है. Because actually the intention of the legislature is not to shift the control of MSME to some outsider. They want the MSME itself to come out of this crisis. Basically, the intention is that the bankers agree to the proposal, or the bankers may ask them to revise the proposal. ठीक है, जैसे बनियों में बजट होता है ना मैरिज का, कि भाई अब वो ये बजट दे देगा सीडी भाई, मेरा तो 50 लाख का बजट है, वो बोलेगा तुम बजट बढ़ा दो, नहीं तो दूसरी पार्टी भी है हमारे पास. तो सिमिलर द सिचुएशन.
एंड यहाँ पे कोई इंटरिम रेजोल्यूशन प्रोफेशनल का कोई कॉन्सेप्ट नहीं होता.
नहीं नहीं, देयर इज नो कांसेप्ट ऑफ इंटरिम रेजोल्यूशन प्रोफेशनल, इट इज ओनली द रेजोल्यूशन प्रोफेशनल. He will constitute the committee of creditors and convene and attend all its meetings. Prepare the information memorandum. In information memorandum also, like in CIRP we know, as per section 29, the information memorandum is to be prepared by the RP. But here, there is a preliminary information memorandum. Preliminary information memorandum is to be prepared by the corporate debtor, and based on this preliminary information memorandum is prepared by the RP. And he will file application for avoidance of transactions also here, and such other duties as may be specified. So the period for filing of avoidance of transactions also is comparatively lesser here as compared to CIRP process. The resolution professional shall exercise the following powers, namely access all the books of accounts, access the electronic records, access the books of account available with government depositories, statutory auditors, etc. He will attend meetings of members, board of directors, and committee of directors or partners, as the case may be, of the corporate debtor. He can appoint accountants, legal or other professionals. He can collect all information relating to the assets, finances, and operations. In case of business operations for the previous 2 years, and financial and operational payments for the previous 2 years, list of assets and liabilities as on the initiation date, and such other matters as may be specified. So this initiation date is the date of filing of the application, and take such other actions in such manner as may be specified. And from the date of appointment of RP, the financial institutions shall furnish all information. So these are the similar provisions which are applicable in case of CIRP also. The personnel of the corporate debtor, its promoters and other persons associated, though they will extend all cooperation naturally. And the provisions of section 19(2)(3), they will also apply. Suppose anybody is not cooperating, auditor is not giving information, then an application may be made to the adjudicating authority, and adjudicating authority may make an order as it deems fit. And the fees of the RP and any expenses, they will be determined in such manner as may be specified. COC, they may impose limits and conditions on such fees and expenses, because ultimately COC will ratify the expenses. And formation of COC is something similar to CIRP. Here the unrelated financial creditors, they constitute the committee of creditors. And if there are no unrelated financial creditors, then 10 largest operational creditors in terms of value, as opposed to 18 in case of CIRP. Provided further that the fees and expenses for the period prior to the constitution of committee of creditors shall be subject to ratification by it. And suppose some expenses are not ratified, then corporate debtor will bear those expenses. List of claims and preliminary information memorandum. Now it says basically it is the duty of the corporate debtor. So corporate debtor shall within 2 days of the prepackaged insolvency commencement date. So within 2 days, he will submit to the RP the following information updated as on that date. It is given in form P10, which is updated from time to time. List of claims along with the details of the respective creditors, their security interest and guarantees, and a preliminary information memorandum. So all these things are prepared beforehand. That is why they can prepare it in within 2 days. So within 2 days, he will be preparing this things. A list of claims and preliminary information memorandum. And based on this list of claims, he will communicate, the RP will communicate with each and every creditor, and he will update the claims if any. And based on this preliminary information memorandum, he will prepare an information memorandum. Where any person has sustained any loss or damage as a consequence of the omission of any material information or inclusion of any misleading information in the list of claims, then every person who is a promoter or director or partner, as the case may be, at the time of submission of the list of claims, or has authorized. This is very important clause 54G2. 54G2 says, suppose a creditor omits the name of a particular creditor. Now, because his name was not included and he may or may not be aware of the PPIRP process. Suppose he sustained some loss because he could not get any money and this resolution process was passed. So in this case, if a person has sustained any loss or damage as a consequence of omission, because primarily it is the duty of the CD to furnish the list of claims, and RP will act only on the basis of list of claims. So if any person say sustains a loss, maybe due to omission of namesake, and so there is a liability cast on the promoter or director or partner at the time of submission of the list of claims. So anyone who was a promoter or director, because in case study question may be asked on this point particularly. So anyone who was a promoter or director or partner of the corporate debtor, as the case may be, at the time of submission of the list of claims or the preliminary information memorandum, or has authorized the submission of the list of claims or the preliminary information memorandum, shall without prejudice to the section 77A be liable to pay compensation to every person who has sustained such loss or damage. So it will become the personal liability of such promoter, director or partner or someone authorizing the submission of claims. No person shall be liable under subsection 2 if the list of claims or the preliminary information memorandum was submitted by the corporate debtor without his knowledge or consent. So now it will be on that person to prove that, okay, this list of claim was furnished without my knowledge or consent. Subject to section 54E, any person who sustained any loss or damage as a consequence of omission shall be entitled to move a court having jurisdiction for seeking compensation for such loss or damage. So here they are talking of a court. It shall be entitled to move a court having jurisdiction for seeking compensation for such loss. Though this compensation can be claimed by moving to a court only, which is having jurisdiction. Then 54H. 54H talks of the management of affairs of the corporate debtor. During the prepackaged insolvency resolution process, management will continue to vest in the board of directors as against CIRP. In case of CIRP, as we know, the powers of the board of directors is suspended and RP gets the control and custody of all the assets. But here the management of the affairs will continue to vest in the board of directors or partners, subject to such conditions as may be specified, and the board of directors or partners, they will make every endeavor to protect and preserve. So the liability of preservation and protection of assets is of the board of directors or partners. Suppose there was some insurance due, they did not get the insurance done and some loss was caused, so they may be responsible for it. So it is the duty of the board of directors or partners. But in normal CIRP, it is the duty of the RP to protect and preserve. The promoters, members, personnel, and partners. In 54HB, they are talking of board of directors or partners. But in 54HC, they are talking of promoters, members, personnel, and partners. As the case may be, of the corporate debtor shall exercise and discharge their contractual or statutory rights and obligations in relation to the corporate debtor, subject to the provisions of this chapter and such other conditions. So the liability is cast on promoters, members, personnel, and partners. So they may be contractually bound, or there may be some statutory rights or obligations. So they will be responsible. But in case of normal CIRP, RP is responsible. Suppose there is some statutory obligation. There is a statutory obligation to file a particular return. In case that return is not filed, whose responsibility it is? The responsibilities of the promoter, member, personnel, or partner, because it is their statutory obligation. They had to apply for a license. They don't apply. Promoter, member, personnel, or partners are responsible. Committee of creditors. The resolution professional shall within 7 days of the prepackaged insolvency commencement date. So within 7 days of the prepackaged insolvency commencement date, he will constitute a committee of creditors based on the list of claims confirmed. Because earlier also there was approval from financial creditors, but that was based on the list provided by the corporate debtor. Here he has confirmed from the creditors also. So he will, based on the list of claims confirmed under clause A. So within, it means within 7 days he has to confirm. Within 2 days CD is providing him in the list, and within 7 days he has to constitute a committee. So he is left with 5 days to confirm regarding the list of claims, provided that the composition of the committee of creditors shall be altered on the basis of updated. So naturally, whenever there is a change, whenever there is an alteration, the committee may be altered. And definitely it will not affect the decisions, any past decisions, as in case of normal CIRP. The first meeting shall be held within 7 days of the constitution of the committee of creditors. So within 7 days, he has to constitute a committee, and within 7 days of the constitution of the committee, the first meeting of the committee is to be held. Now, vesting management of corporate debtor with resolution professional. Normally, the management vests with the board of directors, but where the committee of directors at any time during PPIRP by a vote of not less than 66% resolves to vest the management with the resolution professional, because they see that this corporate debtor is not performing its duties properly. So committee of creditors by a vote of not less than 66%, they may resolve to vest the management of the corporate debtor with the RP. And RP will make the application for this purpose to the adjudicating authority. And whenever the application is received by the adjudicating authority, and they also agree with the findings of the COC that affairs of the corporate debtor have been conducted in a fraudulent manner or there has been gross mismanagement, so it shall pass an order vesting the management of the corporate debtor with the resolution postal. So now the management of the corporate debtor will vest with a resolution postal. Now some additional duties will come, which because earlier the statutory and contractual obligations were of the board of directors, as we have seen. Promoters, members, personnel or partners, they were responsible. But now, because the management has vested with the RP, so he is responsible. And these are some applications of some road duties of RP, IRP, etc. regarding powers of COC. So they will apply to this PPIRP also. Now 54K. And when the management is vested with the RP, he will definitely claim a higher fees. So fees will be of three types in this case. First is fees which is payable to the RP before the initiation of PPIRP. Second is the fees during PPIRP. And third is the scenario when the management is vested in RP, because in that case he is responsible for more functions as compared to the functions he was performing in case of normal PPIRP, because board was also there. But now the management has shifted, the management has vested in the RP, so is entitled for more remuneration for his additional roles and responsibilities. Earlier, the protection and preservation was with the board, now it is with the RP. Earlier, the statutory obligations were with the corporate debtor, now they are with RP. 54K, consideration and approval of resolution plan. The corporate debtor shall submit the base resolution plan to the RP within 2 days of the PPIRP. So within 2 days, because this base resolution plan is already ready. As if we remember, the corporate debtor had already handed over before getting the approval of the financial creditor for initiating this application, a copy of the base resolution plan. So this is already handy with him. So within 2 days, he will submit. And the resolution postal shall present to the committee of creditors. The committee of creditors may provide the corporate debtor an opportunity to revise the base resolution. Because suppose the base resolution plan, okay, it stated that, okay, I will be paying only 60% of the amount due. But the bankers, the financial creditors, they are not satisfied and they want the corporate debtor to revise the base resolution. To revise means naturally to enhance what is the offer, whatever is the offer given in the base resolution plan, they want some more money. So committee of creditors, they may provide the corporate, okay, either you revise or we have to see some other opportunities, or invitation of prospective resolution applicants as the case may be. So sometimes they may provide him an opportunity, okay, you have given us a base resolution plan, but you either improve upon it or we will invite some new resolution applicants. We are getting more offers for our the resolution plans, and the base resolution plan submitted into this section shall conform to the requirements of section 30 subsection 1 and 2, which talks of compliance, etc. And the interests of the operational creditors are not hampered, and the provisions of subsection 1, 2 and 5 of section 30. The committee of creditors may approve the base resolution plan for submission to the adjudicating authority if it does not impair any claims owed by the corporate debtor to the operational creditors. So the committee of creditors may approve the base resolution plan for submission to the adjudicating authority if it does not impair any claims. So there is a condition that it should not result in impairment to the operational creditors. Because why? Because COC is basically comprised of the unrelated financial creditors only. operational creditors are not getting any right to vote or right of participation in normal PPIRP. So there should not be any impairment. It means what it means? It means there can be an impairment to the financial creditors. Now, where the committee of creditors does not approve the base resolution plan. So there could be three scenarios. Number one, there is a base resolution plan. It does not impair the interests of the operational creditors. Then the COC may approve the plan as it is. Number two situation. Second situation is COC may ask the CD to improvise upon the base resolution, or the base resolution plan, it impairs any claims owed by the corporate debtor to the resolution, to the operational creditor. Then the resolution professional shall invite prospective resolution applicants to submit a resolution plan or plans to compete with the base resolution plan. So here also the word used is to compete. It means the base resolution plan has not yet been rejected outrightly, but it will be given a chance to compete. Okay, if you can match the offer, then we will select you only. The resolution applicants submitting base resolution plans pursuant to invitation under subsection 5 shall fulfill such criteria as may be laid by the resolution professional. So the COC will fix up a criteria having regard to the complexity and still scale of operations. Okay, you invite such and such resolution applicants who have got particular net worth, who are able to offer this much, who are able to offer this much as upfront payment. So they may devise different types of criteria, which is basically in the nature of an evaluation matrix. And the resolution professional shall provide to the resolution applicants the basis for evaluation of plans for the purpose of subsection 9. Because as we know, in case of these resolution plans, voting is done based on the marks allotted to each resolution plan. And these marks, they are based on the evaluation matrix. This evaluation matrix contains some quantitative and some qualitative characteristics, like say experience of the resolution applicant, upfront amount, what is being offered, bank guarantee, whether it is being offered, the implementation period, lesser the implementation, better the resolution plan. So the COC in consultation with RP fixes some criteria, and each of the resolution applicant is numbered, is allotted marks based on this criteria out of 100, and then voting takes place. And the relevant information referred to in section 29. 29 talks of information memorandum. The resolution professional shall present to the COC for its evaluation resolution plan, which conforms to the requirements. And the COC shall evaluate the resolution plan presented by the resolution professional and select a resolution plan from amongst them. Now, more resolution plans have come because either the base resolution plan, it impaired the interests of operational creditor, or the offer which was given in the base resolution plan did not suit the financial creditor. So COC decided to invite more resolution plans. So now all these resolution plans will be put up for approval, provided that the criteria laid down by the COC shall be subject to such conditions. Where the resolution plan selected under subsection 9 is not considered for approval or does not fulfill the requirement of subsection 10, it shall compete with the base resolution plan in such manner. Okay. This 10 is very important. Where on the basis of such criteria as may be laid down by it, the committee of creditors decides that the resolution plan selected is significantly better than the base resolution plan. Now, suppose the resolution plan offered say 60% of the amount due. Now this resolution applicant has offered say 80% of the amount due. So this is significantly better. Earlier there was no definition of significantly better, but in the amended regulations, which are not in our syllabus, they have specified what is meant by significantly better also. So if it is significantly better, then such a resolution plan may be selected for approval, and they may not revert to the corporate debtor, because this also puts a deterrent on the corporate debtor that he should not offer too less an amount. He should not offer a resolution plan which does not offer anything to the financial creditor, because this new resolution applicant, he may offer a significantly better plan. And if significantly better plan is approved, then the management goes out of the hands of the CD. But there could be a situation where resolution plan came, but it is not significantly better. Then they will compete with each other. Where the resolution plan selected under section 9 is not considered for approval or does not fulfill the requirement of subsection 10, which talks of significantly better plan, it shall compete with the base resolution plan in such manner and subject. So there will be a competition with the base resolution plan and the new resolution. The new resolution plan, if it is significantly better, COC will select it. They will not go back to the CD. But if it is not significantly better, it is marginally better. Say he was offering 60%, they are offering 62%, 65%. So then they will be asked to compete. Why? Because they want to promote MSME and they want that the management should vest in the corporate debtor itself, provided it competes. If it does not compete, then okay, the management will go. The resolution plan selected for approval under subsection 10 or subsection 11, as the case may be approved by the committee, provided that where the resolution plan selected for approval is not approved by the COC, the resolution plan. So in case there may be a situation where no resolution plan is selected, then the resolution professional will file application for termination. And the approval of the resolution plan will be by a vote of not less than 66%, as in case of normal CIRP, after considering its feasibility and viability, the manner of distribution proposed, taking into the order of priority as given in section 53(1), including the priority and value of the security interest of a secured creditor and such other requirements as may be specified. Now, while considering the feasibility and viability, where the resolution plan submitted by the corporate debtor provides for impairment of any claims owed by the corporate debtor, the committee of creditors may require the promoters of the corporate debtor to dilute their shareholding or voting or control rights in the corporate debtor. This is also a very important clause, because in this case, now it says that the corporate debtor is asking for impairment of any claims owed by the corporate debtor. But please note, the word used here is impairment of any claims. So there may be claims of financial creditor, there may be claims of operational creditor. But if the CD is offering them something less than what was due to be paid, the COC may also ask the promoter, you also dilute your shareholding. You are asking the financial creditor to sacrifice their claims. You are asking the operational creditor to sacrifice their due amount. So what sacrifice you are making? So you as promoter also, you also dilute your shareholding or voting or control rights in the corporate debtor. Provided that where the resolution plan does not provide for such dilution, the COC shall, prior to the approval of such resolution plan, record reasons for its approval. So in case they do not ask the existing promoter to dilute their shareholding or voting or control right, they will record reasons in writing why they are approving. The resolution professional shall submit the resolution plan as approved by the COC to the adjudicating authority. Okay. 54L, then it talks of approval of resolution plan. Now, if the adjudicating authority is satisfied that it meets the requirement of section 30, it will approve. Provided that shall before passing an order, it will satisfy that it has provisions for its effective implementation. The plan, okay, it might be a case where the resolution plan was approved by the COC, but it was rejected by the adjudicating authority because it does not have provision for its effective implementation. And the order of approval shall have such effect as provided under section 31. And they may reject also. Now, notwithstanding anything to the contrary contained in this section, where the adjudicating authority has passed an order under subsection 2 of section 54J. What section 54J subsection 2 was containing? So it contained the vesting of management from the corporate debtor to the RP, and the resolution plan approved by the COC does not result in change in the management. Now, see, the situation here is COC, while during this process of PPIRP, by a vote of 66%, asked the management to shift to the RP. But now this resolution plan, it does not reflect the change in management. The resolution plan is asking for the same management, which was asked to be shifted by the COC. Then in this case, the adjudicating authority will reject the resolution, because any resolution plan also talks of the management, who will be in the management or control of the corporate debtor. So any such person, suppose there was a change which was earlier sought by COC with not less than 66% vote, and the management was vested with the RP, but now the resolution plan which is now being put forth, it is not reflecting such change, then the adjudicating authority will reject the resolution and it will terminate the PPIRP and it will pass a liquidation order. Normally, liquidation order is not passed, but here in such a situation, it will terminate and it will pass a liquidation order. And declaring that the pre-packaged insolvency resolution process cost, if any, shall be included as part of the liquidation cost for the purpose of liquidation of the corporate debtor. So in this case also, the pre-packaged insolvency resolution process cost, it will be included in the liquidation costs. Appeal. 54M talks of appeal against orders under section 54L. So it may be made to the NCLAT. 54N, termination of pre-package, where the resolution professional files an application with the adjudicating authority. Hanji, Vaibhav ji, please.
So we have talked about no haircut to operating credit OCs, right?
Initially, but the resolution plan which is put forth later on, it might involve impairment. They are actually in the base resolution plan, no impairment can be done to the interest of the operational creditor. But suppose the financial creditor, they did not agree to the base resolution plan put forth by the corporate debtor, and they invited more resolution applicants. So in that case, haircut may be there.
Okay.
So 54N, it talks of termination of prepackaged insolvency resolution process. So it says where the resolution professional files an application under the proviso to subsection 12 of section 54K. So what it says, 54K proviso 12, 54K subsection 12 proviso 2. It says, provided that where the resolution plan selected for approval is not approved by the committee of creditors, the resolution professional shall file an application for termination. Okay. So in this case, the resolution plan selected for approval is not approved, because basically if a plan which is selected for approval under subsection 11, because 11 talks of that, okay, the base resolution plan will compete with the other resolution plans. So it may ask for this termination of PPIRP, or under subsection 3 of section 54D. So section 54D subsection 3 54D subsection 3 says where no resolution plan is approved. So in this case also, it will ask for termination. Adjudicating authority shall within 30 days, because within 90 days, they have to put up the approved resolution plan before the adjudicating authority, and 30 days are left for the adjudicating authority, because this entire process is to be completed within a time period of 120 days. So it will terminate the prepackaged and provide for the manner of continuation of proceedings initiated for avoidance of transactions. Okay. Next, where the RP at any time intimates the adjudicating authority of the decision of the committee approved by vote of not less than 66% to terminate. So they even COC may approve termination of this PPIR. So adjudicating authority will pass an order for termination. So in case this process is terminated, the corporate debtor will bear the prepackaged insolvency resolution process. Notwithstanding anything to the contrary, where the adjudicating authority has passed an order for termination, the adjudicating notwithstanding anything to the contrary contained in this section, where the adjudicating authority has passed an order under subsection 2 of section 54J. So 54J talks of, I think, vesting of management. 54J subsection 2. 54J subsection 2 talks of this vesting of management. So in case this vesting of management, the liquidation order will be passed, and this prepackaged insolvency resolution process cost will be included in liquidation cost. This we have read earlier also. And 54O, it talks of initiation of CIRP. So committee of creditors, after this prepackaged insolvency commencement date, but before the approval of resolution plan, they may resolve to initiate a CIRP if such corporate debtor is eligible for CIRP. Because as we know, in case of PPIRP, the minimum threshold is as per section 4, 10 lakhs. But if the default is more than 1 crore, then this company is also entitled for CIRP. So they may, by vote of not less than 66%, resolve to initiate CIRP. And notwithstanding anything to the contrary, where the resolution professional intimates the adjudicating authority of the decision of COC, the adjudicating authority shall, they will terminate this process and they will appoint the RP, and they will declare that the prepackaged insolvency resolution process cost, it will become part of the insolvency resolution process. And where the resolution professional fails to submit written consent, then they will appoint an IRP. And it will be deemed to be an application whenever this PPIRP process is converted into CIRP, it will be deemed to be an application under section 7, and as if it's an application under section 7 had been filed, and the CIRP will commence from the date of such order, and the proceedings for this avoidance transactions will continue. And in computing the relevant time period, the time period for the duration of the PPIRP shall also be included, notwithstanding anything to the contrary contained in section 43, 46, and 50. Because section 43, 46, and 50 talks of certain time period, 75 days, 115 days, and 135 days. So while computing this period, the time period which is taken in this prepackaged, it will also be included. And 54P, it talks of the application of the provisions of chapter 2, 3, 6, and 7 to this. So this was in brief regarding this PPIRP process. Now let us see a case study based on the provisions, so things will become more clear to you. I hope my screen is visible to you. XYZ Limited, let me put it in slideshow mode. Slideshow from current slide. Okay. Now, XYZ Limited, an MSME, applied for PPIRP on 1/1/2022 in form accompanied with documents and requisite fees, which were duly admitted by the adjudicating authority on 15/1. Okay, because within 14 days they have to admit, but this timeline is directory only, not mandatory. Meeting of COC has been called by the RP on 16th March 2022 to consider the base resolution plan prepared by XYZ Limited. The COC is not feeling satisfied by the base resolution plan, and they provided an opportunity to XYZ Limited to improve upon the base resolution plan. However, XYZ Limited expressed its inability to do so. Thereafter, COC asked the RP to invite prospective resolution applicant to submit a resolution plan considering the criteria approved by the COC, having regard to the complexity and scale of operations of business of XYZ Limited. However, out of the 4 resolution plans received, none of the plans was significantly better than the resolution plan. So we have read just now in PPIRP that there could be 3-4 situations. Number 1 situation, there is a base resolution plan which suits the financial creditor, which suits the COC, and it does not contain any impairment to OC's interests. Then that base resolution plan itself may be accepted. Second situation, the COC asks the CD to improve upon the base resolution plan, but he expresses his inability to do so. In this situation, more prospective resolution applicants can come. But and there could be a situation where the resolution plan which has come is significantly better or not significantly better. If it is significantly better, they will outright select the one which is significantly better and they will not revert to the CD. But if none is significantly better, then the resolution plans which have come, they will compete with the base resolution plan. Now answer the following questions based on this. Which of these documents is not to be attached by applying to adjudicating authority by XYZ Limited? So which is not to be attached? Let us please open the forms also. Forms are given at the end of the regulations, PPIRP regulations. If you go to PPIRP regulation and if you are having a copy of the compendium, let me give you the page number also. (3.1)(c)(1). And after the regulations end, so these are the various forms. So form P1, whether it is to be given, let me unmute you all. Now, I think I can unmute you all so that you can answer. So whether consent is to be given or not?
Yes, sir.
Yes, because if you see form P1 is given as per appendix page number 3.1(c)(20). So it starts with to adjudicating authority. So to adjudicating authority, you have to give this consent because the form itself will indicate whether you have to give it or not. Just a minute. Yes, no. If we have to write, so we have to write. So this is to be given. Okay. List of creditors in P2, whether it is to be given or not?
Yes.
No, sir.
Required, sir.
List of creditors actually is to be prepared, but it is not to be given. Because,
No, sir.
because if you see form P2, what it says? Form P2 says list of financial creditors, unrelated, related, operational creditor, related, unrelated. Why this list is being prepared? This list is being prepared to invite the unrelated financial creditors, which constitute not less than 10% of the debt, to come and propose a resolution professional. So this list is that is the basis. So this list is not to be given to the adjudicating authority. If you see the form, things will become clear to you. So you just see form P2 and it will be clear whether it is to be given or not. So this is not to be given. Now approval of terms of appointment form P3, whether it is to be given or not.
Yes, sir.
Yes. What about this approval for filing of application in form P4, whether it is to be given?
Yes, sir.
Because if you see regulation itself will say, I think it is given in the code itself, what documents are to be given. Actually, this form is form 1, application by corporate applicant to initiate prepackaged insolvency resolution process. And in this, what it is giving? Particulars of the proposed resolution, professional particulars of financial operational creditor, affidavit it is attaching, and annexer. So approval for filing is to be given? Yes. Next, consent of AR in case applicable? Yes, it is also to be given. Declaration by majority of directors in form P6?
Yes, sir.
A declaration regarding PUFE transactions?
Yes.
A report by RP in form P8.
Yes, sir.
What is this report? Let us see form
P8 में है. It is included P8.
Ah. So P8 says report of the insolvency professional, because based on this report only, the adjudicating authority will make a decision. This report basically says whether it is an MSME and whether the base resolution plan conforms to the requirement of section 30. A special resolution by members?
Yes, sir.
Yes.
And this base resolution plan?
No, sir.
Why?
Not even written, sir, anywhere.
No, let me again take you to section 54. So section 54A. This is to be given to the financial creditor actually.
Creditors.
Yes. Next. XYZ Limited shall submit the base resolution plan by which date and to whom? If we see the dates, it says because this base resolution plan is to be submitted within 2 days. है ना?
ये आंसर ये होगा.
This application it was admitted on 15th of January.
Seventeenth January.
No, but why not B?
It is not B. It is you have to ask the date.
Okay.
That's why.
Yes. So this is the answer. Next. Which of the following statement is incorrect? So see carefully, it is incorrect. So it is asking which of the following statement is incorrect. The amount payable under a resolution plan to the OCs shall be paid in priority over FCs. This is correct or incorrect?
Answer will be C.
No, whether this is correct or incorrect. This is correct.
Incorrect.
Correct.
No, this is correct. The amount payable under
Correct,
a resolution plan to dissenting FCs shall be paid in priority to FCs who voted for the plan. This is also correct. Affidavit that the CD is an MSME.
It is not correct, sir.
Affidavit not required.
Yes. So this is incorrect.
So we haven't talked about dissenting FCs.
No, actually, whenever we talked of this impairment of assets, impairment of interests of OCs, no? So similar is the case with dissenting FCs. In case of CIRP also, similar situation prevails that the dissenting FCs and the operational creditors, they have to be paid in priority to the financial creditors. Why? Because they did not take part in decision making. So basically they were pushing for liquidation because they did not assess. Yes.
सर
हाँ जी,
सर ये ए करेक्ट कैसे है सर, थोड़ा एक्सप्लेन करना.
देखिए ऐसा है, इन केस ऑफ नॉर्मल CIRP ऑल्सो, ये ना थोड़ा सा म्यूट कर लीजिए, वो आपके ना 3-4 खुले होते हैं ना, उसमें दिक्कत हो जाती है फिर. हाँ जी,
मैं बोलूँ आप करो मैं कर दिया.
हाँ, तो इसमें क्या है कि these OCs normally unrelated financial creditors, they only constitute the COC, है ना? OCs nowhere come into picture. So
Yes, sir.
basically they are ensuring that the interest of OCs is not compromised.
Yes, sir.
So in case of this MSME units, this PPIRP, they are ensuring it more that the base resolution plan does not contain the impairment. In case of
Agreed.
CIRP, there is no such criteria, but here there is a more stringent criteria that okay, OCs should be paid in full and they should be paid in priority over FCs.
Okay.
This is contained in the PIRP process itself. That okay, the base resolution plan cannot contain any impairment to the interest of OCs. So they will be paid in priority to the FCs.
Sir,
There must section
not
32,
having
sir.
an impairment of the
Haan ji.
OCs,
हाँ जी.
not having an impairment of the OCs and paying in priority over the FCs are two different things.
No, that is true, but actually the payment is made as per section 53 only.
So regulation 45, it is mandatory contention resolution.
बी भी
हाँ,
एक्सप्लेन
हाँ.
करना सर दोबारा एक बार.
हाँ जी, बी को, हाँ बी में ऐसा. अरे यार ये म्यूट कर लो भाई. अब मैंने म्यूट कर दिया सबको, है ना? दिक्कत हो जाती है ना, ऐसे फिर प्रॉब्लम आ जाती है. तो क्या होता है, इको होती है ना, फिर सबको डिस्टर्बेंस है. अब हाँ, रेगुलेशन मैडम आप बोल रही थी 45. एक मिनट, मेरे को 3.3.1 खोलने दो. ये आ गया. So regulation 45 says the regulation number 45 sub regulation 5, the amount payable under a resolution plan to the operational creditors shall be paid in priority over financial creditors and to the financial creditors who have a right to vote under subsection 2 of section 21 and did not vote in favor of the resolution plan. So it means dissenting financial creditor. It shall be paid in priority over the financial creditors who voted in favor of the plan. So both these conditions are given in regulation number 45, which talks of mandatory contents of resolution plan.
The same as section 32 CRP.
हाँ बिल्कुल बिल्कुल. And the
Yeah.
resolution.
Section 30 subsection 2 of CRP.
हाँ. So the answer here is C. थोड़ा जल्दी कर लेते हैं इसको, नेक्स्ट देखते हैं वरना पूरा नहीं हो पाएगा. The committee of creditors may reject a base resolution plan. बताइए जी. The committee of creditors may reject a base resolution plan even if it does not impair any claims owed by the CDs to OCs.
B sir answer.
In case नहीं, पहला देखिए. The committee of creditors may reject a base resolution plan even if it does not impair any claims owed by the CDs to OCs. So my question is COC.
Any of the above.
Yeah, COC. But let us see it clause by clause. First, CD has given a proposal. Okay, there is no impairment, but committee may still reject. Committee may still reject because it does not suit them. They are offering 60%. They are asking for 70% of the
But sir,
amount.
it is a base resolution plan, sir.
हाँ तो they may
बेस
reject ना.
हाउ इट इज सर, कैसे होगा सर?
अरे
In
सर जी,
base-
नहीं मैं बता रहा हूँ ना, मैं देखिए
हाँ, सर।
ऐसा है. In base resolution plan, suppose 100 lakhs was the loan amount due. ठीक है. Now they are saying, the CD is saying, okay, I'm offering you 60 lakhs and I will pay to OCs whatever is their due. Financial creditors may not agree. They may reject the base resolution plan. Because the base resolution plan, it will also come in COC, na? So the question here is simply, even if there is no impairment, still this base resolution plan may be rejected. Why? Because the financial creditor may be looking at some better plan. So A is correct. Yes, they can. Now CB. In case it impairs any claims owed by the CDs to OC, yes, definitely they will reject it. In this case, they will definitely reject it. In first case, they may or may not reject it, but in this case, they will definitely reject it. Third, in case it impairs any claims owed by the CDs to FCs, yes, they, in this case also they may reject. So the answer will be D in this case. क्यों चटर्जी साहब, अब क्लियर है नहीं या अभी कोई डाउट है?
नहीं सर, ठीक है, ठीक, ओके.
है ना? हाँ, next. What is the option available to the RP COC in case the resolution plan received from the resolution applicants are no better? Because there could be because they were looking for a significantly better resolution plan, but no significantly better resolution plan come. Now, what are the options available? COC may recommend liquidation. Is it correct? No. COC cannot recommend liquidation. It is only the adjudicating authority which may pass a liquidation order. So COC in no way can recommend liquidation. COC may recommend termination of PPIRP. Yes, they can.
Yes, sir.
The COC may recommend initiation of CIRP in case CD is eligible. Yes, this is also correct. So the answer here is B or C. So there could be even more than one answer. Next. What are the options available to adjudicating authority in case a resolution plan duly approved by COC is put up before adjudicating authority, but it does not have provisions for its effective implementation? Then what it will do? We have just now read. Okay, in case the adjudicating authority, some plan comes to it, but it does not have provision for its effective implementation. Then what is the option available to the adjudicating authority? What is the subsection here? 54.
ही में पास. यस सर, ये तो यस होगा सर.
नहीं, पहले सेक्शन तो बताइए.
हाँ, 54L में 54L
है
54L.
54L आ रहा है. ओके, तो 54L आता है.
54L 4 में है. N में भी
हाँ.
कवर करते हैं.
हाँ, 54N ही है ये. अच्छा, notwithstanding, अच्छा notwithstanding contrary, नहीं ये तो अलग है. ये कहता है in case a resolution plan is put up. Okay. Yes, the answer is given in 54L subsection 3, where the adjudicating authority is satisfied that the resolution plan does not conform to the requirement in this. नहीं, ये भी नहीं है, ये अलग है. इसमें ये आगे आएगा, यहाँ नहीं आएगा. ये 54M हो गया, ये 54N में आएगा ये. अभी तो पढ़ रहे थे हम लोग, 54O में था क्या? अभी पढ़ रहे थे ना हम इसको, 1 मिनट में यहाँ से बेयर कोड से ना आप क्या करो, यहाँ जा करके इसको ये कंट्रोल F करते हैं, इसमें कंट्रोल F करके इम्प्लीमेंटेशन देख लो। अच्छा 11 बार यूज हुआ है यहाँ पर, ठीक है इसे छोड़ो। फिफ्टी 54L में आता है ये, देखो ये क्या कहता है, provided that the adjudicating authority shall before passing an order satisfy itself that the resolution plan has provision for its effective implementation। तो अगर ये नहीं होगा तो क्या होगा वो देख लेते हैं। हाँ चट्टोपाध्याय जी, क्या आंसर है इसका? कौन से सेक्शन में आ रहा है? हम तो एक्चुअली सेक्शन देख रहे हैं।
हाँ हाँ, मेरे को आंसर
54
तो 54L में दिख रहा है, बट की बात जो है सर,
ये कह रहे हैं
कंफ्यूजन है थोड़ा सा, मेरे को भी है। 54J से लिंक किया हुआ है एक्चुअली लिक्विड सर। रिजोल्यूशन बिना रिजोल्यूशन कैसे जाएगा, ये तो क्वेश्चन खड़ा हो रहा है ना सर।
1 मिनट 1 मिनट, अभी तो पढ़ रहे थे हम लोग ये। फिफ्टी 54L में ही इसका आंसर मिलेगा कि भाई इसमें वो तो फिर क्या करेगा, इसमें वो टर्मिनेट कर देगा प्रोसेस को। अंडर सबसेक्शन 2। इसको स्टॉप शेयर करके और वहीं चलते हैं इसमें दोबारा उसी पे। ये था ना हमारा। अच्छा यहाँ बोलते हैं 54N। 54N टॉक्स ऑफ दिस टर्मिनेशन वेयर द रेजोल्यूशन प्लान अंडर द प्रोविजो because this 54L 2 also says the adjudicating authority shall, before passing an order for approval, satisfy that the resolution plan has provision for its effective implementation. So basically, in this case, the question here is whether A can pass liquidation order or not. I think liquidation order can be passed only in the scenario where the COC asked for shifting of management and the new resolution plan does not reflect this choice. So that is the only situation where liquidation order may be passed. So here in this case, they may order for termination of PPIRP. So I think the answer here will be B, because liquidation order can be passed only in a situation where there is an approval of COC for shifting, and this the resolution plan, it does not reflect this choice. So only in that situation, the liquidation order will be passed.
54L4 में जो है सर, that was the limited in 54L4. Only the 54J is related. The vesting of managements. That is only one case you can liquidate.
बस बाकी में लिक्विडेशन
That is the
ऑर्डर
thing.
नहीं।
Initially मैं यही बोल रहा ना।
बिल्कुल 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 ठीक है। ये वाला ये वहीं पे चलते हैं दोबारा। तो खैर anyway we can discuss it in the group also. तो अभी मेरे हिसाब से इसका आंसर जो है यही होना चाहिए आपका बी। बी शुड बी द आंसर। नेक्स्ट देखते हैं। What are the options available to adjudicating authority in case A order vesting of management, but the resolution plan approved by COC does not result in change in management? तो in this situation A may pass a liquidation order. यहाँ पर भी liquidation order pass कर देगा। Next देखते हैं। Let us do it quickly.
That is possible. That is if 54J is there.
हाँ।
That is in case of this is possible.
हाँ, which of the following statements is not correct?
7 में लाइए सर इसको।
हाँ 7 में, हाँ जी। हाँ बताइए बताइए।
That is the first होगा D, second होगा B, उसके बाद A. This is seniority अगर देखिएगा।
हाँ हाँ।
First year reject the sub plan.
हाँ।
B होगा pass an order for termination. Last होगा the liquidation. That is seniority DBA. मेरा
राइट ठीक है, बिल्कुल सही बिल्कुल सही। बल्कि चारों ही हो जाएगा, रिजेक्ट भी कर देगा।
हाँ रिजेक्ट तो रहेगा, फर्स्ट रिजेक्ट रहेगा,
सारा ही कुछ हो जाएगा, ये डी भी हो जाएगा।
रिलेटेड टू 18J, दिस इज द मेन क्वेश्चन।
हाँ
अब यू हैव इन्वेस्टिंग चेंज ऑफ मैनेजमेंट इज देयर।
हाँ बिल्कुल बिल्कुल।
दिस क्वेश्चन द 54L4 it will apply.
Yes. So we have to refer to 54L4 for this. So it will reject the resolution plan, terminate the process, declare that the cost will be recovered. It will be included in liquidation cost. Achha. ठीक है। तो इनिशिएशन ऑफ CIRP इसमें नहीं होगा, है ना? हाँ, DBA होगा इसमें, DBA। नेक्स्ट देखते हैं, which of the following statements is not correct? Basis for evaluation of a resolution plan includes parameters to be applied. Yes. ये तो होता है।
D होगा इनकरेक्ट सर।
है? हाँ, ये तो करेक्ट हो गया ना, पहला तो करेक्ट हो गया।
D इनकरेक्ट।
हाँ, includes manner, ये भी ठीक है, ये भी करेक्ट है। Can be to be disclosed in the invitation for resolution plan, ये भी ठीक है। It is to be disclosed in the invitation for resolution plans. Basis for evaluation of a resolution plan. basis for evaluation of a resolution plan. It has to be disclosed. Yes, it has to be disclosed. Need not be uniformly applied to all the resolution applicants. Basis for evaluation of a resolution plan.
Incorrect, sir. That is incorrect.
कैसे incorrect कैसे होगा?
Uniformity is applicable in all regional applications. There should not be uniformity.
चलो आगे देखते हैं. Which of the following statements is incorrect? थोड़ा सा अगर इसमें कहीं भी कोई confusion होगा ना, तो we can discuss in the group. Which of the following statements is incorrect? अब ये बताइए. पहला वाला क्या है? Significantly better plan may or may not be approved by the COC. Significantly better plan may even be rejected. Significantly better plan signifies better by at least 25%. Significantly better plan signifies better by at least 10% in terms of the score. पहला तो करेक्ट लग रहा है हमें.
हाँ.
दूसरा भी करेक्ट है, तीसरा भी करेक्ट है, चौथा ही इनकरेक्ट है बस. क्योंकि सिग्निफिकेंटली बेटर में अब 25% का क्राइटेरिया आ गया. और
But it applicable है क्या सर? It is applicable now.
अभी नहीं एप्लीकेबल, वैसे अगले में एप्लीकेबल है. और बट ये है कि सिग्निफिकेंटली बेटर प्लान को वो रिजेक्ट तो नहीं करते नॉर्मली. सिग्निफिकेंटली बेटर प्लान वो रिजेक्ट नहीं करेंगे. ये है कि और significantly better plan may or may not be approved, but I think here the answer should be D in this case. Next देखते हैं. The process of improvement of resolution plan. ये जो improvement है, इसमें की विंडो कितनी देर के लिए ओपन होती है?
Hours, sir, 48 hours.
Yes.
48
पहला तो ठीक है, दूसरा वाला देखिए. ये भी सही है.
हाँ.
Improvement can be done by at least a tick size. ये भी सही है.
ये भी सही है.
The resolution plan having higher score may not be considered by the COC for approval. Yes, ये भी सही है. क्योंकि क्या होता है कि resolution plan it may or may not have effective means for its implementation. तो अगर implementation भी जरूरी है उसका. If implementation is not there, if there are no effective means of implementation, तो high score से ही खाली कुछ नहीं होगा. तो all these statements are correct इसमें, क्योंकि इसमें कुछ पूछा ही नहीं है हमने. तो all these are correct. नेक्स्ट केस स्टडी बाद में देख लेंगे. आई थिंक वी कैन स्टॉप हियर, है ना. सो किसी का कोई क्वेश्चन हो इससे रिलेटेड या किसी भी चीज से रिलेटेड